Good afternoon, everybody. And I just wanted to have some preliminary remarks. Thank you to ITAG and to BCIC, I'm sorry, for allowing me to come and address you. And thank you also for your interest in this very important topic. I think it's wonderful that all eyes are on India right now, and I think it's for very good reason, especially in the IT area and the IP area, as I don't think it's any secret that there's a stronghold of knowledge here and a very hard-working culture and a lot of innovation as well. So I think with the advent of IT and IP kind of converging right now, I think it's a very exciting time to be in the type of areas that you're practicing in and that you're developing your businesses in. And so I do thank you for allowing me to share a couple of remarks with you. I'm going to take this from the perspective of the U.S. patent laws, and I know the Indian laws are developing and they're going to be different. But I think because India is becoming a world trade partner for a lot of entities, that it's good to have that kind of background in terms of launching your products in the U.S. or in a different locality that is going to dictate how your patent applications look in India should you choose to pursue your protections in a foreign country. I'll just start just with some basic background about the legal foundations of patent laws in the U.S. So probably about over 200 years ago, the founding fathers had in the U.S. were kind of stuck trying to start from scratch, as it were. And so how do they hit the ground running in a situation like that? Well, part of their legal document included the concept of, well, we're going to encourage innovation. We're going to encourage people to think and create, and hopefully that'll help the nation grow. And so I don't think it's really any secret that the correlation between intellectual property and economic conditions are closely tied. And so I think the U.S. has benefited from that foundation that from the outset, we're going to promote the progress of science and useful arts. And so this allows some sort of limited monopoly, some economic advantage for a limited period of time. But in exchange for this economic benefit, you're going to have to be forthcoming with your technology so other people can improve upon what you've done. As everyone stands on the shoulders of everyone who's gone before them, right? So this is just part of the bargain. So inventors from all around the world can obtain patents in the U.S. on a very wide variety of topics. And I think this phrase has come up in the discussion, Dr. Ghosh's discussion this morning. The U.S. patent law recognizes patents for pretty much everything under the sun. It's a very inclusive definition of what you can get a patent on. And I think that behooves the U.S. in many ways. So they're looking at people who are inventing or discovers any new process, machine, manufacture, or composition of matter. There's a requirement for the new and the useful, meaning that the invention has to be novel and it has to be non-obvious, which is a whole another series of discussions, really. So I'm just going to focus on the first hurdle, the basic 101 issue, which is kind of appropriate because with any fundamental learning, you always start with, 101. So this is Patents 101. So I'll make a little disclaimer with regard to getting a patent for everything under the sun made by man. Almost. The following is a list of things that do qualify for patent protection in the U.S., and it is fairly inclusive. Even with Bilski, you still can get patents for business methods. This includes operational methods, improving systems operations, and things of that nature, and any improvements thereon. Because it's not just the pioneering patent that they're looking for. And it's good if you can go way back in the process and get a patent on the basic algorithm, But the U.S. recognizes that those improvements count because the improvement can go any one of different ways. So if you happen to take one way, and that's the way that the commercial markets adopt, then you should be rewarded for being the first to invent that. Electronic devices, performing business methods, any applications of laws of nature or mathematical formula, the media encoded with software, not the software per se, again, that kind of strange software per se prohibition. The patents don't protect that, but I think the Founding Fathers had no idea that software would ever exist. So you just do not see that kind of terminology in our statutes. Let's see. Anything that's transforming signals that might represent a physical process, these are all things that the patent law will recognize. It's very far-reaching, it's very broad, and it's only limited by your imagination, really. The following do not qualify. There's some things that you're not going to be able to get a patent for. Things like gravity, basic natural laws and principles, basic a formula, Pythagorean theorem, E equals mc squared. You can incorporate it in what you do, but no one is going to get a patent on such basic ideas. You cannot be too abstract. And this is where it gets a little bit tough with regard to the information technology issues that are really prevalent in an information-based age. So you kind of have to make your U.S. patent look a certain way before it's going to pass muster at the U.S. Patent Office. Okay, so Bilski has been raised a couple of times already. And what it comes down to is something called the machine or transformation test. An applicant can show that a process claim satisfies Patents 101 by showing that the claim is tied to a particular machine or that the claim transforms a physical article into a different state or thing. Okay, so that's pretty straightforward, you would think. And it's known as the machine or transformation test, or sometimes shorthanded as the M or T test. Okay, let me go back and say that Bilski did change a couple of things. If you think of, in terms of like the pendulum swinging, probably the widest swing in favor of patentable subject matter came out in State Street Bank, where all they were requiring was that the claim provide some useful, tangible result. And as you may recall, the State Street Bank concept had a patent claim that was trying to assign a value for stock. So you're dealing with a number. And it's pretty abstract, but I mean, the valuation of something, that's pretty important. It's useful. So at that time, the court had said, okay, you can go ahead and get a patent for that. I think Bilski kind of starts the pendulum swinging back the other way a little bit. And they said, no, that test is really no good anymore. So please don't use a useful, tangible result as a basis of showing that a claim should be granted a patent. Despite that, the Federal Circuit is not saying, don't bring your business methods to us, we're not going to give you a patent. They stopped far short of saying that, and I think they specifically said, no, please continue to file your applications for business methods. We're not providing a blanket prohibition against such methods. And then, I guess again, in connection with the Bilski matter, which was manipulating some pretty abstract ideas, they said that you can try to make it look like a transformation, but if it's just an abstract idea, like for a legal obligation or risk, that is not going to be sufficient to pass muster under the Section 101 tests. Okay, so I'm going to ask you to read the claim through just briefly to get some background about the Bilski case. It's basically a hedge fund type of method. They have a series of transactions between 3 people in a transaction. So there's the source of the commodity, some middleman that's going to modulate the risk between the 2 end parties, and then you're going to have at the far end the user of the commodity. And the description of that particular patent specification was the risk that the consumer needs to buy some commodity items such as electricity or coal. And if the price gets too expensive, that consumer is going to bear a lot of risk. And so the market participant would be the person supplying it. And if the price gets too small, then it's the market participant, the supplier, that's going to bear all the risk. So the claim of Bilski says, well, I'm going to put someone in the middle to moderate that risk and set, let's see, the last part is initiating a series of transactions between the provider and the market participants at a second rate such that the series of market participant balances the risk position in the series of the consumer transactions. Okay, so that's what they think of as the benefit. And under the useful tangible result test of State Street, that probably would have passed muster. It is useful to be able to control your risk. But under Bilski, that claim was rejected as not being patentable under 101. It's basically, there were a couple of different stages. Here, the examiner rejected the claim because it was admitted not to be tied to any particular apparatus. If you look at the language, there's nothing in there that suggests there's any machine involved in this process at all. I mean, it's a pure method claim. And so there was some difficulty with regard to satisfying a machine test or to keep it from being too abstract. There was nothing in there to save it from being a mere abstraction, which is not patentable under the U.S. patent laws. The U.S. Board of Appeals took the case on appeal and declined to apply this no technological arts test, meaning it looks like a business method, and so we're not going to give you a patent on it. That's not the test that they wanted to apply. They said that it would still be statutory if there was some sort of transformation. And I guess here, that risk was not really tangible. It's not a physical transformation of anything. It just happens to be a number. It's a useful number, but it's not sufficiently created. There's nothing generated based on just having that risk number. And that is basically the basic downfall of that particular claim. And I would kind of add here that the transformation test, I think if they had done something in terms of trying to do something with that risk result, like perhaps controlling a transaction, either allowing it or not allowing it based on the risk number, they would have been a lot better off in terms of trying to meet the transformation test. Because then you're converting that number into something else. You're turning a flat number into a type of control signal. And I don't think that there's going to be quite as high a hurdle to say that that should not meet the tests for 101. And so in terms of the background of the Bilski analysis, it was pretty well settled that with the 1952 revisions of the U.S. patent laws, that methods are fair game. If you claim a method, you should be able to get a patent on it. So the Bilski claim was a method patent, so what was the problem? It seemed to fall within the statutory language. It was a method, after all. The general statutory language was narrowed by the Supreme Court by excluding certain things that I listed in a previous slide. There's no patents for laws of nature. There's no patents for natural phenomenon, and no patents for abstract ideas. And that is the downfall of the Bilski claim. And there's one additional element. Well, before I go on to the additional element, I just wanted to make you aware of some Supreme Court examples with regard to the transformation tests. One of the famous ones is Diamond v. Deere, and you may be familiar with this case. It's basically using some sort of chemical formula or a chemical equation to decide when the rubber for a particular particular apparatus had reached a certain amount of cure. And as a result of that, once it reached it, it would end the process and, open up the mold or whatever. And basically, even though it used an equation, used an algorithm, it still satisfied 101 because of the fact that it was being used to transform the liquid rubber into a cured rubber. And so there is a transformation in that circumstance. So here the Supreme Court was willing to draw a distinction between using some sort of patent claim that's going to preempt every use of this equation in comparison to one where the equation is going to be used for a particular use. Another case, another very famous case that was used in the Bilski case was the Gottschalk v. Benson case. And this is the case where they were basically trying to transform BCD code into pure binary code on a computer. And you would think, well, there's a computer involved. There's a machine there, so why didn't this satisfy the machine or transformation test? And here the court said, well, this conversion is basically it's too basic. The only time you really want to make this BCD to pure binary conversion is for use on a computer. So they weren't going to allow this particular patent holder to basically keep everybody else from using the equation to program computers, since it would cause too much of a preemption of what they thought was a fairly basic relationship. So there seems to be a little bit of wiggle room even under the machine and transformation test. And I think it's causing a lot of confusion among practitioners and certainly within the patent office at this time. So hopefully the Supreme Court heard Bilski, I believe, in early November. And so we would expect a decision from the Supreme Court sometime this spring. I just want to talk about some kind of corollary results that came about because of the basic preemption considerations. What if you say, well, I'm only going to limit this BCD conversion on a computer to, I don't know, washing dishes. I'm going to just say a method of washing dishes that uses this. This kind of slap-on limitation of the method is not going to be sufficient to meet the requirements of Section 101. It's called the field of use limitation because it's not sufficiently going to preempt anyone from using the computer in the basic sense. If you decide to do something as simple as like displaying your result, or print your result, or store your result as a result of a particular conversion, a particular data conversion, that's probably also going to fall in the category of not being a significant activity. So that's the insignificant post-solution activity exemption is not going to convert your non-statutory claim into a statutory claim. I think the courts are also pretty clear that data gathering is not a sufficient physical step. And like I mentioned before, the display of numbers from a calculation also will not satisfy the transformation test. Okay, so those are kind of the things that won't help you in terms of your Section 101 analyses. So I do want to turn our attention a little bit to the examples of physical transformations that will help you. In the Abley case, there was a case of graphically, the Abley case, I guess, is still kind of one of those post-solution activity tests in terms of displaying the results of a statistical calculation. For that particular claim, it wasn't going to be enough to say, I've made all these calculations based on some data that I generated. That type of claim will not pass muster, but in the same case, there was going to be a case where the signals represented some sort of X-ray data, for example. And in that situation, because there's a representation of a physical manifestation being the medical image, that claim would satisfy the physical representation or transformation test under Section 101. And then I guess the last example I wanted to discuss was the idea, again, it looks like a business method. It's a method of conducting an auction of items where you're trying to maximize the bid price. They thought, well, it's still a little bit too abstract. And it's not the fact that it's a business auction. It's the fact that you're looking at an abstract number. It's just not something that you can put your hands around. And so the court remains uncomfortable with giving patents on such things. Despite what I've said, I do want to emphasize that Bilski does not preclude patentability of business methods per se. And also, along the same lines, it would not preclude patentability of operating methods per se. So things like strategic ideas, or strategic methods, I should say, are still fair game. You just have to make your claim look a certain way to pass the examiner's tests for patentability. Let's see. And again, the fact that an equation may appear in your patent claim because you need to use the equation for some reason, that's not going to be fatal to your claim as long as you apply it to provide some sort of either a physical transformation of some sort. And I'll try to go through some examples in a few more slides. Okay, this is just the summary of the Bilski test again. You're looking for a machine or transformation. That's basically the outcome. Right now, we're probably about a year and a half past the original Federal Circuit Bilski decision. And it's before Bilski, I never saw a 101 rejection, ever. Do a lot of patent applications in the medical imaging arts. And up to Bilski, I never saw a 101 rejection, rarely. And ever since then, every single case has a 101 rejection, even though it's clear that it's being tied to a medical image. In many cases, it's a computer-based system. It's tied, or it's directed to an apparatus. I think the examiners are a little bit afraid of issuing a case and being punished for it down the road, so they're erring on the side of being overcautious. But as an advocate for an applicant, I try to give them some, try to give my clients a little bit of counsel in terms of not necessarily taking the path of least resistance and adding process claims or a processor into what is basically their method claim. Because it's not clear what's going to happen if they decide that they want to litigate or license that claim. If you tie it to a processor, does it mean it's going to be one single processor that's doing every step? Can the process be split up in a couple of different machines? I mean, it just raises a lot of unintended consequences to try to rush the patent through by simply sticking a processor in what you originally wanted it to be a method claim. And I would say that even though Bilski put forth the test in the disjunctive, it's either a machine or a transformation, the examiners are pretty much ignoring the transformation part. We've tried to argue that there's a transformation of a medical representation, a signal representing some medical data, and it gets transformed to make something clearer or to make something less noisy. But it's been an uphill battle in terms of trying to make a 101 rejection go away simply based on the transformation test. But hopefully that will change in the coming months. Okay, so the USPTO has provided some interim guidelines in view of Bilski. And this will, I guess the interim meaning they're going to wait for this to see what the Supreme Court tells them to do. But basically, the examiners need to consider whether there's a preemption that goes on, such as in that case where you have a BCD to binary conversion. And they're also going to look for some particular application of the method result. The U.S. examiners are instructed to find that the transformation test is met where there is a transformation of electronic data so that the data is suitable for different function or use. That's what they're being instructed to do, but in reality, they're taking a very rigid look and actually requiring some sort of computer to be recited in the claim. But hopefully that will change and go back to the way it was pre-Bilski. And finally, the examiners need to consider whether there's a law of nature that's basically being claimed apart from some sort of practical application of the method. I apologize for the text on the slide being a little bit blurry. This is basically drawn from some of the examples on the USPTO website. So if you'd like to, you can just go to www.uspto.gov, and it'll be replicated there if you just search for Bilski interim guidelines. So these guidelines have been in effect since about September 2009. And I think the process is pretty straightforward. They're trying to meld together all the Bilski issues. And starting at the top of the chart, they're going to decide whether it's directed to a method or not. And if it's going to go to a method, then they're going to take a different flow chart. And if it's directed to something that's not a method, meaning it's an apparatus, they're going to do a couple of additional tests. They're going to look for the law of nature. And if it's a law of nature, it's not going to pass 101 requirements. They're going to look for the practical application. That's in P4. And then they're going to see if there's a preemption. That's kind of the final test. And if it passes all of those, then it will go ahead and pass the first hurdle, the 101 hurdle. It still has to clear the issues of novelty and non-obviousness, but right now the section 101 hurdle is not really trivial. Okay, so and the USPTO guidelines also provide some fairly examples. I think they're pretty straightforward, and I think kind of a little bit artificial in terms of their complexity. But I think it's pretty straightforward, so I won't go through any of these in detail. But at bottom, they're just basically looking for a machine or a transformation of some sort. If it doesn't meet either of those prongs, then it's going to be thrown out for lack of subject matter eligibility. So I guess just very briefly, this method just describes some fairly abstract concepts. They're going to sort some results, they're going to rank some results, and they're going to compare the results. And a lot of this, you can kind of do something like this in your head. And if it kind of passes that I can do this in my head test, you probably need to add some more language to make it look more like a transformation of some sort. Okay, so this is basically the same language as the previous example. The only language that was added is this, in the comparing step, there's the use of a computer or a processor. So under the interim guidelines from the USPTO, that small phrase is enough to get you past the 101 hurdle because it meets the machine prong of the test. And this is true even though there's no transform recited in these claims. And then this is one additional example where they put the additional data gathering step at the top of the claim. And this is kind of thrown in there to show examiners that if it's something that's insignificant in terms of insignificant pre-solution, post-solution activity, then it's not going to move one claim from the non-statutory subject matter to the statutory subject matter. And again, it doesn't meet the other requirements for the machine or the transformation. I'm going to talk very briefly about some decisions from the Board of Appeals. These are some cases that went up on 101 issues or lack of novelty and lack of obviousness issues. And I'll give you a minute to kind of read through the claim, and I'll let you decide whether it should have passed 101 or not. So basically, there's a lot of processor recitations in there. So you think, okay, it looks like it should pass the machine or transformation test. You're normalizing a couple of different operands. You're going to predict using a processor whether some floating point operation is going to be small. And based on the result, you're going to proceed down a hardware-based calculation or a software-based calculation. Okay, here's the test. How many people think this should pass 101? How many people think this shouldn't pass 101? For those who thought that it shouldn't, if you wouldn't mind just shouting out why you think it doesn't pass, I won't pinpoint where the answer's coming from. You should submit your resume to the USPTO board. That's exactly the rationale that the board said, this doesn't pass muster under 101. There are a couple things going against this claim. It recognizes that there are a couple of processors going on, but it looked like, well, what are you using this processor for? You're just kind of using it in an abstract sense. You're going to calculate some intangible result D, and then based on that, you're going to decide to calculate some other insignificant result. So they thought that there's no way that we're going to allow this to pass 101 issues. And I think also, in the back of the board's head, they're looking at, okay, I'm going to calculate something on a computer. It's like, everything does that. So we can't possibly allow this method claim to prevent everybody else from getting a patent on such a basic exercise. So in this case, they said, no, you have not passed 101. So very good. Okay, let's try this one. And again, I'll give you a minute or two just to read through, looking for some of the key items that we had talked about already. Okay, so this is a transmission control method. And basically, it looks like there's some sort of code that's embedded in the data that says, if the code is there, process it one way. If the code is not there, process it a different way. Either allow the transmission to go through or don't allow the transmission to go through based on your result. Okay. How many people think that this should pass 101? Okay, how many people don't think that this should pass 101? I think this is a much tougher call. Right now, again, there's no machine that's being recited in here. And it looks like you're actually going to be using the result to do something differently. And it's a very odd decision in that, 101 was never raised by the examiner, so it should have sailed through after the board reversed the Section 102 and Section 103 rejections. You would think that the applicant was going to be really happy. But what happened is, because of Bilski, the board decided to apply a new rejection under Section 101. And the rationale that they applied just makes it leaves me completely confused, because arguably that last step where you're taking the result and processing something differently based on that result, that looks like a transformation. You're taking the result and going to make some sort of processing decision based on it. And the board's decision actually said that, yeah, I guess this could have a transformation in it. I mean, they conceded that in the written opinion. Yet at the same time, there is no machine, so we're going to reject it under 101. I think it's this overly cautious approach that the PTO is taking right now that's creating a lot of friction and static in the case law. So I don't agree with the board on this one, but that doesn't mean a lot. But the court said, despite the fact that we said it's a machine or transformation test, and the fact that this actually looks like a transformation, and the examiner never rejected it under 101, we're still going to say it doesn't satisfy 101. So these are the things that we're contending with right now. They're basically afraid of making the wrong decision at this point. Okay, this is an easy one. Oh.
Maybe it's not the transformation, it has to, the transformation has to transform an article. In this case, let us say this request message itself got transformed after this so-called process, step, wherein the message got changed. Then maybe they might have felt that this is a transformation. Since there has been a decision made, but there has been no transformation of the article in question here. Probably that may be one of the reasons why.
Yeah, so if you were a patent attorney, and you should apply for a job if you aren't one, if you were a patent attorney, you could make that kind of adjustment in the claim language to make it look like something that the US Patent Office would allow in terms of the 101 issue. Yes? That's probably going to be an insignificant post-solution activity. Did everyone hear the question? If I understood it correctly. Is to transform your result and put it to some sort of medium. That is basically storage of the data. It's not really a transformation of it in terms of how the USPTO is going to view the question. So you got to do a little bit more than display, print, or store. But I think there are ways to kind of get around this as best that you can, and just trying to think of some way to make it look like it's becoming something different would help a lot. And you can make it, you could do it in terms of like scale. You can make it something that it's clearly transforming something physical. It's going to, this is probably not the best example to work from, but you can make it clear that it's transforming something physical. Or you can make it somewhat more subtle to say that we're going to change it so that the use is slightly different. And a couple slides ago, I had indicated some case law that said that should satisfy the test if you're able to use it for a different function or for different use. And arguably, that last step of determining whether to allow the transmission or prohibit it, you're transforming a signal from a plain number to, a key. So anyway, this one leaves me scratching my head quite a bit. We're going to end with an easy one. You're going to take a look at this one. And, well, I already gave you the answer at the bottom because I think it's pretty clear cut. This is about as abstract as you're going to get. And it clearly looks like it's abstract. It's almost directed to software per se. To the extent that I've ever seen anything that looks like software per se, I think this would be it. So, I mean, I think this kind of generation of a software object representing this and that, or not even representing, but it's, I think it's clearly non-statutory under US patent law. Okay. So just a couple of claiming strategies if you decide that you want to transform your Indian application to something that's going to go to the US Patent Office. The easiest way is to make a signal represent some sort of physical transformation. In certain technologies, that's easier. In a pure IT sense, maybe it's not that easy. But for the physical entities, you just have a signal representing some physical quantity, an amount of ink, an amount of chemical, some intensity representative of a body part. Okay, that's a lot easier. Because you'll meet the transformation test. You can talk about outputting the signal in a viewable format. As long as you have the transformation part in there, what they call an insignificant post-solution activity, it really doesn't matter because you've already met the other hurdle that's required. You can kind of try to make the adjustment based on some sort of course of action based on the signal representation. Or you can like I mentioned before, keep narrowing your transformation. Make your transformation more and more specific so that the first kind of quasi-abstract transformation you try to make doesn't pass muster. Your much more specific transformation will. And the last step, the last way would be to actually recite a processor in your claim. But if you're trying to claim a method, I just don't understand the concept of throwing a machine in there. Okay, the claiming strategies for business or operational methods, I think this is a lot tougher. I think because Bilski specifically said we're not going to preclude method patentability, that should be a license to try to be fairly aggressive in terms of how abstract you claim something. It's kind of trying to capture your patent protection at the most abstract level. And it's that value as a patentable claim, you'll be much better off, and I think you'll be in a better bargaining position whether you're trying to kind of get out of a very strict indemnity clause or some other reason. Patents right now are pretty fungible. It's not just a matter of shaking a stick and saying, give me some money. It's also saying, give me access, give me freedom to operate. So you do want to try to get some basic patents on your software technologies. And so I do think that you can try to have a step of obtaining a signal that represents your personal or financial data. And at that point, I agree that's probably pretty abstract. So even if you have that kind of manifestation, you're going to have to make it look like a transformation is occurring somewhere based on that data. Like I had mentioned before, allow a transaction or terminate or prohibit a transaction. Under that example that I showed from the USPTO, that might be a little bit iffy. I don't think that's going to necessarily get you out of the woods. You can try, because that decision just makes no sense in terms of the disjunctive machine or transformation test. You can try to, the US Patent Office has given patents for data conversions if you're converting data so it's storable in one machine versus a format storable in a different machine. There's a transformation there. That has passed muster in the past. And IBM, when these guidelines came out, they specifically clarified in the record that certain patents that had this kind of transformation should still fall within the purview of Section 101. So you might want to try to say that the data that's being processed somehow improves the process in terms of how it's stored, or makes it more efficient, or somehow takes fewer resources, and try to make some sort of processing decision based on those types of efficiencies. And then as kind of like a fallback, and I can't say that it necessarily will be successful, you can try to narrow the field a bit more, so you can say that it's limited to transactions for personal data representing, likelihood of someone developing a certain disease or something like that, and taking a course of action based on that. So those are some of the tricks that you might try to use as a matter of linguistics, really, because words are all we have in terms of legal practice, to try to make it fit into the statutory category. I just want to say a few words about the Supreme Court hearing. The questions presented, as I mentioned before, were pretty narrow. They're going to decide whether the Federal Circuit was overly rigid in saying that it had to meet this machine or transformation test. And I think most practitioners would say that it's a little bit too confining to say that this is the only test that you are allowed to apply for Section 101 analyses, since there is a lot of other case law out there. I don't think the pendulum will swing all the way back to State Street because of the abstract concepts that were involved in terms of just calculating a number. And I do think the Supreme Court did want to consider whether the decision was going to preclude business methods. It doesn't seem like the Supreme Court is leaning that way to say that business methods should be precluded. I mean, there's some statutes that are currently existing in the U.S. case law that allow for business methods, so I can't see that being the outcome. These are the types of, I guess I've already covered these 2 points in my previous slide. One other observation from the Supreme Court transcript is that they were desperately looking for a transformation in that Bilski claim. If you go back to the Bilski language, I mean, they were trying to see, is there actual purchase of this commodity? Is there any kind of exchange going on that could possibly look like a transformation? I think the justices were trying to find something in the claim language here that would suggest that there's a transformation involved. So I think just based on the facts that are being presented and considered by the Supreme Court, I doubt Bilski will get their patent as far as like a 101 issue is concerned based on the existing claim language, but I don't think they will be precluded necessarily from trying to pursue a different route if they add the appropriate additional transformation requirements that the Supreme Court precedent has traditionally required. So I guess that was the last point that I wanted to make. So I do thank you for your attention and your participation. It is not an easy issue to resolve, but it's something that I think can be worked through, and I think we'll all be waiting for that decision from the Supreme Court in a few months' time. And if you have any questions, I'll be happy to answer them either now or during the rest of the conference. So thank you very much.